Yes, the Employment Equity Amendment Act of 2013 introduces in Section 6 a new subsection that says a difference in terms and conditions of employment between employees performing the same work or similar work or work of equal value, the reason of which is based on one of the listed grounds or an arbitrary ground, constitutes unfair discrimination. What is important about this amendment is firstly that it is located under the prohibition on unfair discrimination. So it is not a generalized egalitarian type provision in our law. It has to do with unequal pay, where the reason for the unequal pay is unfair discrimination. So that is the first important thing to note. The other thing that we must note is that this is not actually a change in the substance of the law. The prohibition on unfair discrimination was already contained in the 1995 Labour Relations Act. At that point it was contained in Schedule 7 to the Act, and with effect from the 1st of December 1998, the Employment Equity Act took effect, and the prohibition of unfair discrimination was then located in the Employment Equity Act. We've seen a whole lot of cases already, well, not a whole lot, but some cases dealing with equal pay for work of equal value, and those cases were actually brought under the LRA and more recently under the Employment Equity Act, under the general prohibition of unfair discrimination. So it's not that the law is changing in substance, but certainly the right to equal pay for equal work or similar work or work of equal value is now flagged by this specific provision in the Employment Equity Act. And for that reason, we think that there might very well be an increase in the claims that we will see in the Labour Court. So now the next thing that one may ask is, what is work that is equal? So work that is the same or similar or of equal value. Now when you talk about the same work, like for example we saw in the Ntai versus SAB case where black employees were complaining that they were treated less favorably than white employees who were all training instructors, that is quite clear. They all have the same job description, they have the same duties, they are performing the same tasks on a day-to-day basis. But that is not the only instance that this may apply to. Also, where employees are performing work of equal value, there is a provision now that says you may not discriminate unfairly on the basis of the listed grounds or an arbitrary ground, like race or sex or language or religion or any of those grounds. Now, in order to make that assessment as to whether work is of equal value, there is a two-stage inquiry that you need to undertake. Firstly, you must determine that you are in fact comparing apples with apples. Is the work actually of equal value? And in order to make that assessment, the courts will look at factors such as the responsibility attached to the work, the skill objectively required to perform the work, the conditions under which the work is performed. For example, is someone working underground, someone on the surface, is someone doing night work versus day work. So objectively speaking, we look at the job and we see what is required for the performance of this job. Responsibility, skills, qualifications, all of those things. The effort that goes into it. And then we say, all right, these two jobs are of equal value. And once we are satisfied that the jobs are of equal value and that there is in fact a difference in how these employees are treated, then we go to the second leg of the inquiry and we look at the individuals performing the work. And again, the regulations that are still in draft form but which we hope will be promulgated soon, they make provision for justification as between individuals. So for example, if someone is performing better or doing more work, so the output is more, the employee seniority is perhaps more, there perhaps was an employment history of performance increases. All of those kinds of factors will then come into it in order to say actually it is not because of race or because of gender or language or religion or whatever the alleged discriminatory basis is. It is actually because of seniority or performance or whatever other proper, rational, justifiable ground the employer can point to. So the list of justifications that we see in the regulations is not going to be exhaustive. It is examples of what an employer could hook the differences on. But if the employer can show another objective basis for differentiating between the two individuals concerned, that should be acceptable. Now, this raises very interesting questions when you look at it from a market perspective, because often what employers tell us is that, well, we pay the male employee more than the female employee because he bargained for more. Or we pay the white employee more than the black employee because the black employee was willing to come for less. Now those kinds of arguments will be very interesting, and it will be very interesting to see how the courts eventually deal with that. In the UK, those kinds of defences were not regarded as sufficient, and the courts there have said that actually this is exactly why we have the Equal Pay Act. It is in order to make sure that we do not entrench unfairness and unfair discrimination, and therefore employers would be well advised, firstly I think, to make sure that they have proper grading systems in place and job evaluations in place, and secondly that where there are differences in pay between employees of different races and sexes, that they have actual proper justification for that. In our discussions with job evaluation companies, they tell us that actually the payrolls of many employers are all over the place. There's no sense of, yes, you are a new hire, so therefore you come in at this level. Some are employed at that level, some are employed at that level. And we think what this addition to Section 6 is going to do is to ensure that employers justify differences in pay, so that we move more towards a culture of justification than what we probably currently see. But yeah, it's an exciting time. It's going to be interesting how this pans out in the case law through our courts, and there is lots of work for employers to do. I think one of the important things is that they will probably have to do audits to see if there are differences in pay, especially along race lines or gender lines, and then to take proactive steps to deal with those differences in their